I'm Andy Gavil, and it's my pleasure today to be here with my colleague and friend, Harry First. Harry, I'd like to talk to you a little bit about how you started.
My pleasure to be here, too.
Well, don't get snozzy with me so fast. Harry, you graduated from law school in 1969, and you clerked on the Supreme Court of Pennsylvania for a year after that. And then you went to work for the Antitrust Division during the Nixon years. Tell me a little bit about how you got into antitrust and what it was like to work at the Nixon White House Antitrust Division.
Well, I remember the first thing was asking my antitrust professor, Louis Schwartz, whether it was a bad idea to work for a Republican in antitrust. And he said, no, actually, the Republicans believe in antitrust. It's the Democrats you have to watch out for. So he turned out to be right. I was interested in antitrust, I think in part because of Louis' course, in part because of what was going on at the time, the sort of the late 60s. Big wasn't great, small was beautiful, and very much, not so much an economics view of antitrust, but a democratic view of antitrust. And he was a great teacher, an inspiration. He was also the time of Ralph Nader, so he also was able to get some money for me to work for Ralph Nader in the summer of 1968. So this is the anti-business, in a sense, aspect of antitrust. And it was very interesting to work for him. And then when I finished my clerkship, over to the Antitrust Division.
What kind of work did you do when you first arrived at the Antitrust Division?
Well, in their great wisdom, they put me in the appellate section. Great wisdom because I had no clue about trials, and I'd just done an appellate clerkship. So I came in, sort of doing the usual stuff that came through the appellate section at the time, a lot of which actually had to do with regulatory work. So I worked on a number of different things. I remember telling my immediate supervisor that I didn't want to have anything to do with the war. What would antitrust have to do with the war, you might ask? But there was one ICC case which involved getting permission to ship bombs more quickly. So he allowed me not to work on that case. So that was the anti-war part. But then I also got assigned to the appeal in the cases that were brought against ITT. As we can remember, you and I, and maybe some of the people who ever watched this tape. During that time, Richard McLaren was head of the Antitrust Division, and there was this big push to deal with conglomerate mergers. These were the days when the Antitrust Division litigated merger cases, and they brought 3 cases against ITT, in which they were extremely unsuccessful, and the district court lost them all. And I was assigned to write the memo to the Solicitor General to explain, to do the recommendation as to whether we should appeal to the Supreme Court. You could then, at that time, appeal cases directly from the district court, civil cases, to the Supreme Court. But you had to file the appeal. So I got to write the first draft of this memo as to why we should appeal. This was the merger that involved Grinnell, which was a fire alarm company. So it was great because this was obviously high-level policy stuff for the Antitrust Division, and it wasn't clear that everyone in the Antitrust Division agreed with these views, that there was a good theory. It was sort of complicated. So that was interesting to work on.
But something was going on in addition behind the scenes in the ITT
Yeah, there were
case.
things that I didn't know about going on involving ITT, which later came out, which were payments to the Republican National Committee that ITT was going to make, and a lobbyist by the name of Dita Beard, and all of this stuff. I had no clue. All I knew was that this was a hot case, and I knew it in part because I received a call one day from a reporter for the New York Times. Now, who am I? I'm just, I'm 1 year out of law school. I'm nobody in this case, right? So he calls me and he says, let's meet. We should meet. I'd like to talk to you about this case. I said, okay, so we met in...
Did he introduce himself as Deep Throat?
No. Not yet. That was coming. So we met in the lunchroom at the Justice Department, and he said, "I know you're working on, you've worked on this memo." I don't know exactly how he knew all this stuff, and I'd really like to get a copy of the memo. Why don't you leak it to me? I'm thinking, what? Am I crazy? He said, "I'll tell you what, they'll never know it's you. We'll have a dateline on it of Denver, Colorado, as if it was released there." And I said, "Well, let me think about it." So I looked at the memo, and I saw there were 5 names on the memo, people who'd been involved in it. The last name was mine. There was no one who was going to leak that memo except for me. And so I said no.
He had apparently already tried the others.
He didn't bother to try the others. The memo did leak, by the way. It did come out. It came out through, I think, Kennedy's committee that also had a copy of it. But that was another story. When it came out in the New York Times, my boss called me into his office and said, closed the door. He said, "So did you leak this?" So I got in trouble even though I didn't leak it.
Even though you didn't.
And then one Saturday morning, I remember waking up and the news goes on, and there's a story the case had been settled. I didn't know anything about it, obviously, but the fact that a case you've been working on is actually in the news as it continued to be in the news. So that was sort of fun. But it wasn't anti-war time in the Justice Department then. It was a little strange. My other anti-war story, then we can move on with something actually interesting to antitrust. I remember I had to go over to the Federal Communications Commission to drop some papers off. And I take a cab back, and I get into the cab, and the cab driver says, "Where to?" I said, "Department of Justice." He turned around and said, "They still call it that?" I thought, oh, great.
Far out.
Far out, yeah, that was good.
So you started the Antitrust Division. That's how you sort of got your foundation in antitrust and developed your interest a little bit. But then you turned to teaching. So tell me a little bit about why you decided to leave the Antitrust Division and your first teaching job, which was at the University of Toledo.
Yeah, that's a great question, Andy. Why did I leave? I thought it was time to try something different. It was a time that you sort of thought you could do anything. So I'd done 2 years there. I thought, so what should I do now? Well, maybe I'd go to a trial section. I talked to people actually in the patent section to go there. I thought, well, maybe I'll go to a private firm. I talked to them. They only represented bad people. I didn't want to do that. And I thought, well, maybe I'll try teaching. So I did that. But the sense that I had at the time was, well, I'll see what that's like. That could be interesting, and maybe I'll like that. And if I don't, so I'll try something else.
And did you start teaching antitrust when you entered teaching?
I did start teaching antitrust, yeah. I taught a lot of things at that school at the beginning, way too many. But yeah, I started right off teaching antitrust, and it was exciting and interesting, and so plus corporations and other things, I don't know.
Mm-hmm. So you were in Toledo for a few years, and then 1976 is the move that takes you to NYU, and you join the faculty there, where you've been since that time.
Right.
Tell me a little bit about how you started at NYU, and then I want to talk a little bit about what that time was like in the history of antitrust, because as we know, right after 1976, it really starts changing in antitrust, and you had just begun teaching, and we'll talk a little bit about that. But tell me what it was like when you arrived at NYU in 1976.
Gee, I was in New York. This seemed pretty good to me. A lot of stuff actually was changing, and you're right, antitrust was changing a lot, although it had started before, and to sort of, as you go back in the antitrust division that I joined, antitrust was not heavy in economics, obviously, we know that. And yet, before I joined the division, I was given a book about industrial organization theory to read. And then the chief economist at the time was George Eads, who did a course for the lawyers in the antitrust division, an economics course, micro industrial organization course, using Mike Shearer's book, actually. And so people were clearly gearing up that this was more important and was coming, but it had not yet quite arrived. So the big change that was coming was much more economics. And the whole world of antitrust was about to change in ways that, that no one could have predicted, I think. But so the first thing that I worked on when I came to NYU, this was as a visitor, was a review of Richard Posner's antitrust law. It's just the economic approach to antitrust law, first edition. And so it was a good introduction for me to really dig into that. I had a great first line that he hated always and was completely wrong. I said, "There's nothing quite so compelling as an idea whose time is passing." I was so prescient, right? So not a great predictor of.
Let's put these couple of things together because it's sort of interesting. So while you're at the Antitrust Division, you really have this sense, looking back at it certainly, that economics was becoming more important. It was being introduced, studying the industrial organization material of the time. And you get to teaching, and obviously you had some sense that this really was going to be important because you chose to write about Posner's book. What are your recollections of how you reacted to Posner's thinking about economics and how it should apply to antitrust?
Well, I didn't like it, but one of the things that was clear then is clear now. It was a consistent approach to antitrust that challenged what people were doing, and sort of made people, me included, I was just starting out, but try to step back and explain things that just seemed right, but maybe didn't have a good explanation for, and maybe didn't have a full-fledged theory for. It's still, in a way, sort of the challenge for antitrust, in a way, is still reacting to that basic critique from Posner and Bork eventually, and and the Chicago School, as we call it.
Now, Bork's Antitrust Paradox comes out in 1978. So
right.
Again, you're a relatively young scholar.
Right.
You've looked at Posner, you've written about it, and then Bork's book comes. Do you remember your reaction when when the Bork book arrives, the Antitrust Paradox?
Yeah, more things that were wrong was my reaction, but then I had to figure out why. And one of the things that was good, of course, is that it helped to make what you were teaching, more challenging in a way, because you could use that critique and try to teach the critique, and try to explore in class and in writing what might be right or wrong about the critique. But it was a great challenge to how things had been going, and of course all the political changes that were coming. Or about to come in the Reagan administration. So, it was. Antitrust always is challenging, but it was a challenging time.
But it's sort of, it's interesting to look back now and really think about that period. So 76 is Posner's book, and 78 is the Bork book. You've started teaching in 76. It's the Carter administration. You don't know that 1980, the big revolution is coming, and that's going to sort of allow the Chicago School to take off at the government level. 1977 is the Sylvania case. And Sylvania seems to suggest that the court is going to go in that direction. So what was your reaction when you read Sylvania, and how did you incorporate it into your teaching?
Well, slowly, in some sense. I think whenever something, an important Supreme Court case comes down, you look at it closely, you sort of fit it into what's gone before. You don't yet see how it fully changes what's gone before. So the question, of course, at the initial stage was, well, how much will that change the law? Obviously it overruled Schwinn, so it was a change from that period. So it was a matter of sort of incorporating those things, but there were still more things to go. You remember, the IBM litigation was ongoing at that time. Mm-hmm. The AT&T litigation was ongoing. You had two major monopolization cases that were heading, but who knew, in 78, heading towards either dismissal or settlement. But so there was still a lot of major enforcement stuff that was going at the same time that you started to see, who knows where it would go, cutting back from the Supreme Court. Cutting back had started in the mid-70s as well, even before Sylvania in the merger area. So a lot of the doctrine was changing. And, it's always, first comes well, we've got to teach this new case. Then comes sort of how does it all fit in, and will it matter in the long run?
Do you remember at any point feeling like, boy, the game really has changed? Sylvania happens.
Yeah, I don't remember it so much what I remember is thinking in the 1980s that I might be teaching the history of antitrust, and that the case book would consist of ripping pages out of the book as things really started to change. And yeah, at that I think the feeling of major change didn't come right at the instant of those cases. It came as it all sort of settled in. Bill Baxter comes in. It's clear that enforcement's going in a different direction. Although AT&T's settlement and IBM is quite different, but still, there's a feeling that this is an area that's starting to recede. I felt it was a distressed industry. Student enrollment started to slip. When I started NYU in the mid-'70s, we were running, at one point we were running 3 large antitrust classes every academic year. So that meant about 300 some of 365 roughly students in any class were taking antitrust. It's a huge percentage. Once the 80s hit, students who are very smart moved on to other areas because the practice was changing. A lot of things were changing, and I'm not sure it was all so clear, just from those Supreme Court decisions. There were all sorts of changes to how antitrust is practiced, and on the academic side, how it was written about.
Now, you said a few minutes ago that you really didn't agree with Posner when you read it, and you didn't agree with Bork's critique. But now it looks like it's beginning to take hold. So what is it that you didn't disagree with, that you did disagree with? And do you look back at that today thinking maybe they were right, or do you still feel like the critique was right?
I think basically the movement has been to accept the legitimacy of economic analysis. While still trying to think about whether each theoretical answer really works in the real world. So the thing that I've always liked about antitrust is the attachment to the real world, is the concern for how things are actually happening, for how industries actually operate, for who gets hurt, who's benefiting. It's sort of the ground up, the inductive approach. I think over time, I still get concerned that the theoretical deductive approach produces results that disconnect from the world. But I think over time, everyone has become more willing to say, okay, these are appropriate tools to use. Certainly we have to be much more concerned with economic consequence. But still, I never went into antitrust to think, what we need is a law that aligns price and marginal cost. That's our main goal. If we could just do that, we'd be fine. That never seemed to me what antitrust is about. Still doesn't. But I think over time, everyone in the field has accepted the centrality and legitimacy of economics. And then the question is, whose economics? Which, then you have to learn more about economics. You have to be able to put up supply and demand curves on board and all of those things.
And you have to teach it.
And then you have to teach it as well.
And students fall asleep.
Right.
And
No, they never fall asleep. They drop the course. They say, oh, no. I always teach the economics part after drop out is over.
Very important. No graphs before
that's
drop.
Right.
Make that note. Now, at some point, you come back to, obviously, someone who was one of your mentors, Louis Schwartz. He was your professor at Penn. And along with him and John Flynn, you joined them on their casebook. And I'd like you to talk a little bit about your memories of them and their views of antitrust, and especially the impact it had on your own views.
Right.
Let's start with Louis Schwartz, who really had developed his reputation in the 50s and was very highly regarded. You got to have him in law school and then join him as a co-author. So let's talk about him.
Right. Well, he was from the now derided populist school of antitrust. He actually believed that bigness wasn't so great, and really was very concerned about corporate size and government size from a political standpoint, I think. I mean, not that I've had high-level political conversations with Louis exactly. I was afraid of him. I mean, he was too, he was so, he was I hate to think that he was the old teacher. He probably was not so old. But, he was the master and the star. And, his background came out of the New Deal. He's one of those people who had done antitrust and securities work. Mm-hmm. And when I had him, he also taught criminal law, which I still do. And he was the second in command in the ALI Model Penal Code. So he was doing both of these things. And so he's not coming at antitrust from, that pure economic theory perspective. He's really coming at it from the point of view of what's happening on the ground and a concern for concentrated economic power. So that, I tuned into that. I thought that was a great message. Not everyone in my class, I remember, necessarily liked that. And he helped me get my job at the Antitrust Division. A recommendation from him. I remember, hearing that was, it was a great thing. When Louis and John they had done a revision of Louis's casebook, and when they wanted another author, because Louis didn't want to do it anymore, they asked me, and I was thrilled, that they would ask me to join them. And at that point, actually, Louis bowed out. He said, he had argued with John over parts of the casebook for years, particularly over phrasing and commas. And he was tired. He didn't want to do that anymore. John tended to put everything in the book. He was, let's add more stuff. And Louis always wanted to take it out, particularly the jurisprudence, which, theory was not what Louis wanted to follow. So he didn't really have anything to, he just said, it's yours now. And then John and I worked on it for, over the years, really. And that was a great partnership in a way. John was a great includer of things, and my task was to try to take some of it out. And he was interested in sort of the jurisprudential approach to how you make decisions, and what the rule of reason is about from a jurisprudential standpoint, and very concerned about misuses of power. And he was the one who then had the political experience, being counsel to Phil Hart for a while, so he had the sense of how Washington worked or didn't work, and what the political fights were in Washington, particularly the fights over smaller business franchises and things like that. So that's what John was about, and John was he was a wonderful guy.
I was going to ask you. He was a colorful character too. He
Yes.
was very genuine.
Yes.
So just talk a little bit about John as a person.
Yeah, John liked to talk. He was Boston Irish, so this tells you a lot about his background.
Who winds up in
Boston
Utah.
Irish, who winds up in Salt Lake City with the Mormons, and very much an iconoclast in that environment. Highly critical of the university, of things in the church. I mean, just everything. But John used to like to talk about how he played saxophone at one point with Maynard Ferguson, and he had somewhat of a colorful background in that sense. And there was this sense of having done a lot of things in the world, and he was very sort of generous personally with the people he worked with me, with his students. He was really a very special person, and he wrote a ton of things. Last year after he died, we put together some memorial stuff of his, and you and I were at a conference, at his retirement. But when you look back, he wrote about a lot of the important areas in antitrust law, in Section 2 of Rule of Reason, and even no-fault monopolization, an idea we're going to revive yet.
Are there anything specific, looking back at both Louis and John, that you feel really influenced you personally by way of their example and also in terms of your own thought about antitrust?
Yeah, well, I think in part, I'm not sure whether it's influence or just, being in the same spot. I think probably of the three of us, I was actually the most willing to try to grapple with the economics. I don't think Louis, it just wasn't involved when he was there. John fought against it, and I've tried to use it and deal with it, probably more so than they. But not for John, not for Louis or me, has this always been about economics. It's been, just antitrust as being something broader than that, dealing with how power is dispersed in our society. So that's why we still start our casebook with Alcoa and hope that every other casebook editor has taken it out, because it really distinguishes ours from theirs and really talks about power in a political sense in ways that we, sort of out of the conversation to some extent today, but not necessarily completely.
Would you describe it as antitrust as political economy?
Yeah, it's more. It is political economy, and I think that always was Louis' view. You were always looking for the political aspect of what was going on. This was, the rules, the law was sort of never straight. Oh, we've got it. Economic theory will explain it all. There's way more going on behind it, and part of the effort was to pierce behind that and see who was doing what and what the reasons were for it. So, and a belief that you could actually do something with antitrust law, accomplish something, not that it was something that, oh my God, was a third rail not to be touched, unless you happen to fall on it. So that it was a tool that could actually achieve certain results and help people and business firms in the economy.
Now, in addition to the injection of economics into antitrust, surely one of the other major developments in our field in the last generation has been the globalization of antitrust. And twice you had the opportunity to go to Japan. You had Fulbright fellowships, once in the early 80s, once in the early 90s. Tell us a little bit about what attracted you to go to Japan and what kind of studies you
Okay,
did
so
there.
I'll go back again to Louis Schwartz. When I was taking antitrust...
You see, I knew he influenced you in other ways.
I never thought of all these things, Andy, until you just mentioned it. So I can remember, I think he took, maybe it was a sabbatical. Here's my memory, it's really clear. I think it was a sabbatical, or maybe it was a summer, and he went to the south of France to do something about antitrust, because it was European antitrust. I said, I want to do that. If I can get myself to, abroad to the south of France, I'm there. So, the interest in sort of the internationalization of antitrust, actually, when you think about it, I'm thinking about it now, is something that began after World War II. And that really was the first injection, in a way, both in Europe and in Japan, of really pushing antitrust out into the world. And Louis was very interested in that, actually, in the European part. So why Japan? That's a great question. Here's the real answer. My first sabbatical was coming up, and where should I go? Well, everybody goes to Europe. That's pretty easy. So the year before, I was doing a seminar actually on business crime, and I had a Japanese law professor in my class. His name was Kishida. And he says to me, Japan has an antitrust law. I said, no, I didn't know that. I don't even want to. This is like 1981, I guess. I said, no, I don't know. He said, yeah. I thought, gee, that's the place. I'm going to do that. So then I started doing a little reading and said, this is sort of interesting. And so, I'll go to Japan and learn about Japanese antitrust law. Now, there was this minor problem. It's called Japanese language. It still is a bit of a problem. But, I was able to do enough in English and meet enough people and, read a little bit of Japanese to actually learn quite a bit, in fact. And it was, in some sense, it was partly luck. But, of course, why was this guy from Japan studying at NYU, right? He knew that the world was an international world, and the law school was attracting people like that. So it was consistent with that. But lucky for me, this was really the time when Japan was really breaking into the headlines as a major economy and a problem for the United States. So it's really the period from really that spans the two sabbaticals, or the period when Japan is going through the height of its economic power and is a major policy problem. So I was lucky. I mean, I managed to pick something that was interesting. The sushi was good. Fascinating country. Got a chance to go there with my wife and two daughters, and and infected them with this Japan stuff that's going to affect their lives forever. And it was important, as an economic policy matter. And Japanese antitrust law turns out to be sort of interesting and still interesting. So,
were there significant differences you noticed 10 years apart going there and seeing where their thinking was in terms of antitrust?
In terms of antitrust, the difference between the two periods was that in the late 80s, we had started to put a lot of pressure on Japan to open their markets. Structural Impediments Initiative, if you remember SII, part of which was an antitrust initiative. They're not enforcing their antitrust laws. They have all these distribution restraints. It's very hard to enter markets. And the Japanese should use their antitrust law to break the cartels that are domestic and basically open up the economy. It was pretty closed to outside investment. To it was hurt the Japanese as well. So a difference was, by the time I got there the second time, they had been responding, the Japan Fair Trade Commission, to a lot of these pressures to change their antitrust law to have some more enforcement. A lot of what they were doing at that point was sort of reflexive against SII, but at the same time they did discover that there were cartels, actually, shocked to hear this, in Japan, that were a problem for the Japanese economy. So they were starting to prosecute things. There was a lot more. It wasn't quite as supine an agency, and they were as the Japanese have often done, is they were paying attention to what's going on in the outside world. So they were, but more reactive of that. That's something that's still going on, actually. But so that had changed, and the economy had in fact opened up somewhat. You could find some more American products, but Japanese culture is very enduring. It does not really change overnight.
1999, you hear the call of government again, but at a different level and in a different way. And you're asked to become the head of the Antitrust Bureau in the New York State Attorney General's office. And it's a year after the Microsoft case has been filed. Tell me what drew you back to government, and then we can talk a little bit about the Microsoft case.
Well, I've had a lot of lucky things, actually, in my career. Hopefully this will still continue, Andy.
Until this interview.
Until this interview, it's been great, and now it's downhill, or it's the end of the line. I got a call, would I be interested in doing this? I had another sabbatical coming up. I thought, why don't I want to, well, maybe this would be sort of interesting to do. I don't know. What do I know about state antitrust law? Nothing. I knew nothing about state antitrust enforcement. We're all at the federal level, and all of that stuff, looking out to Japan. But what New York is doing? I don't know. I mean, I knew a little, but not all that much. And so I went in and met with Eliot Spitzer, then Attorney General. Never met him before. Didn't ask me anything about my politics, but then he probably knew what my politics were to the extent that, I wasn't a Republican. And he was very interested in having antitrust enforcement and very responsive to it and understood antitrust. He'd actually done some antitrust cases when he was in the DA's office. It's sort of an odd thing in a way. It looked like a really interesting opportunity. I didn't know how interesting it was going to be, I must say. I just thought, when am I going to get this sort of opportunity again, work for someone who says, basically, I'll let you do what you want. I'm looking for you to do something. And that was true the 2 years I was there on leave. I basically was able to do the things that I thought we should do. And I didn't have to trim any of them. And the only thing I did trim is that we had a very small staff. But other than that, it was great. And so what do? I walk in on, as I knew, but I walked in at sort of the tail end of the trial of the Microsoft case. And what could be better? I mean, I didn't make the decision to bring it, and in the end, I didn't settle it. I just got to do the fun part in the middle, which was to work on the appeal, basically the end of the trial, post-trial stuff, and the appeal. And it was, a tremendous learning experience, an important effort, and an interesting political experience because being in New York, you sort of have to learn about how all of the states work. But you also have to learn about how the federal government works and how the Justice Department works and how that interaction goes with Joel Klein at the Justice Department at the time. And it was on stuff that mattered, something that mattered a lot. So that was great. But that wasn't the only thing. When I first came in, I said, how am I going to know what cases to bring? What do I know about this stuff? I said, I'll read the newspaper. After a while, I dreaded getting the newspaper because what was in the newspaper? Another merger, another merger. At that point, it was United U.S. Air, their first attempt to merge. All New York's upstate markets were U.S. Air markets. I can't just pretend this isn't happening. And it was just one thing after another that it was just a constant challenge of more and more things just simply happening, as opposed to saying anything about what I'd like to think about, what areas maybe to have the Bureau move into. Internet commerce was strengthening at the time. That's clearly going to be a problem. But who had the time? There were, the fireworks were going off all the time. So it was a great challenge, and and I learned a lot. So that was great.
Now, one of the consequences of the Microsoft cases was a lot of public debate and discussion and even criticism of the role of states in these sorts of nationwide cases. At the time and looking back at it, how do you feel about the role of states in nationwide, not just the local things, but in the big antitrust cases that affect lots of states?
Yeah, I think it's, in some ways, I think in terms of Microsoft, the state's role was very important, critical at some periods, less critical at others. It was very useful during the trial, but it may have been more critical at the point of deciding to bring the case. It was, useful on appeal, but became critical again on settlement and remedy. I think the states added a lot to that. I think at the same time, there are obvious problems or questions from the state's point of view as to whether this is the best use of the state's resources. And these cases are very time-consuming and difficult. But I think that there is a case to be made in the right case, national case, for state involvement, at least because it helps give more political root to a case. In other words, there's more. This is not just some bureaucrat sitting on Pennsylvania Avenue in Washington deciding to bring the case. There's support actually from state AG's offices, and the state AGs, after all, are the ones who are elected. It's not the Assistant Attorney General in charge of antitrust. So there is that political quality which can be very important in gaining legitimacy for antitrust policy. There are obvious problems, and states can make mistakes, and they can be abusive, and do all sorts of things like any government agency can. But I think there is an important role. I think the states played it in Microsoft, and it was great fun. It's just great.
So you've been an antitrust lawyer, professor.
So
now.
Are you going to say how many years, Andy? Yeah, right. Yeah,
since the beginning of our
since
conversation.
Since the beginning of time, right?
Until
yes,
now.
Right.
Until now.
Right.
How do you synthesize it all? Obviously, a lot of change in those 40 years. What do you think has been positive change? What things do you think maybe have been negative change? Do you come back once in a while to thinking about Louis' thought that this is really a game of political economy, and what really has happened is just a shift of power? This is the big thought question. Looking back over the 40 years, what thoughts do you have?
Yeah, well, I think a lot of people, are nostalgic for the way things were back then, assuming they can remember the way they were back in whatever day they were. And I think, there's an inevitable onward movement, a lot of it driven by technology today and how the world is changing. So, our sense of what you need in an economy for diversity, for, to deconcentrate economic and political power may be a little different today than it was then. Even a number of large companies may give you that some degree of deconcentration and diversity, and technology may enable new firms to come in and people to have new opportunities, entrepreneurial opportunities. But I think that the basic thrust of antitrust as being democratic in a little d sense, as providing, as free enterprises, providing freedom and opportunity, I think that's actually pretty strong. I mean, I think that endures. And it endures beyond, do you have an efficiency defense? Or, gee, maybe we can, is a 3-2 merger okay now? In the end, what will keep antitrust alive and well will be a concern about freedom, not necessarily about efficiency, as important as that is, but is about freedom and opportunity. And I think that's still important. And I think in part I always wonder with all the countries that are adopting antitrust what they think they're adopting and what it is that they think antitrust means. And I think they probably see it more in power terms than in P equals MC terms. The efficiency of the victor rather than in fair opportunities and open markets and things like that. So I don't know. Is that a big enough thought?
It's a pretty big thought. I like it. I think Louis would like it too. Harry, thank you very much.
Thank you, Andy. This is good. This is
Hope
good.
you enjoyed it.
Thank you.
Thank you.